Obviously, the Smollett family, they're very, very happy with today's developments. The legal team, Ms. Waddell, Mr. Allen, Ms. Walker, and Mr. Lewis, and myself, we're very elated about this. Let me make something clear. There is no room for politics in our court system, and our appellate courts in this great state do not play politics. Let me make something clear. When this case was initially re-indicted, when this case was prosecuted, when this case was sentenced, at each of those steps, I wondered to myself whether Chicago has seceded from the Union. Because in this country, you cannot punish a person twice. And while everyone was focused on the sensationalism surrounding this case, people were not focused on the constitutionality of the prosecution. And we've been trying to tell everyone that. It is unconstitutional to charge someone twice. Mr. Smollett paid a $10,000 fine. Let me repeat it again, because our appellate courts are listening. Paid a $10,000 fine and did community service. Now, there's no time machine to go back in time to undo those things. His $10,000 fine hasn't even been returned to him, right? And then you re-indict the case and you give him 30 months probation for a Class 4 felony with a man with no criminal record, felony record. 30 months probation, you give him 150 days in jail. You give him what else? You make him do restitution of $120,000, and then you give him the maximum fines. You know, and there's something wrong with that. We've been complaining about the disparate treatment of African Americans in the judicial system, regardless of what you think about this case. Some people might think Mr. Smollett is guilty. I disagree. We all disagree. But that's okay. You're entitled to your opinion. But the real question is, should black men be walked into jail for a Class 4 felony? Shame on you if you think they should. That's a disgrace. It's wrong. We're talking about decarceration in this day and age. The Trump administration, the Obama administration, the Rauner administration in Illinois, and people are still trying to lock black men up, and it's a disgrace. Now, the judge's sentencing, I couldn't disagree more with it. The judge spent a great deal of time chastising, berating my client. I've never seen that, and I thought it was unprofessional. That's my personal opinion. Not happy with that. And we look forward, now that this case is gone to the appellate court, to actually having finally an intellectual conversation about the constitutionality of this case. I'm not playing politics. That's all I'll say for now.
It's no coincidence that we're here today. I think we're here because the appellate court realized this was the right thing to do. I hope everyone realizes that the persecution that went on in that courthouse was absurd, and that the sentence was a draconian sentence. It was excessive, and I've always called this case a Class 4 murder. Apparently, this case was more important than the 20% clearance rate of the murders that are here in Chicago. Apparently, any citizen in Chicago, if they want to, if they don't like the decision that this duly elected official makes, can saunter into the courtroom and ask for a special prosecutor. I hope every citizen of Chicago realizes how important this case is, because this could be you. You may think, oh, that's ridiculous, I would never do these things that he's accused of. But you can definitely be charged for something you didn't do. You should never, ever be charged again for something that you had already been prosecuted for. It's important. Do not minimize it. It's not a joke. Thank you.
It should not be minimized, the issue of being tried in the court of public opinion and having to feel that you need to prove your own innocence. That goes against a major tenet of not just, obviously, Illinois, Cook County, but the United States judicial system. Mr. Smollett had to come into this courtroom 2.5 years after this incident occurred and felt that he needed to prove his own innocence. And again, that's patently unfair. That's not how the system works. That's not how the system should work. And the sentence that Judge Lynn doled out was completely devoid of any sort of intellectual curiosity or prowess. And I think, again, the appellate court, we're very, very much looking forward to having a non-political discourse with them that is intellectual, that's understanding of the laws, that are understanding of what Class 4 felonies mean, what the statutes are designed for by the legislature of this state. And again, moving forward, I hope that everyone understands, like Mr. Allen said, the very important nature of this case and the implications for every single citizen of this state and of this county, that anybody is capable of being charged with a crime, anybody is capable of being charged with a felony, and you are absolutely entitled to not say a word, you're absolutely entitled to speak in your own defense, and you're absolutely entitled to representation by attorneys. So we're very elated that Mr. Smollett is out, and the work is not finished at this point.
We are just pleased, we are overjoyed that the appellate court was able to cut through the politics, to cut through the smoke screen, and was able to understand that we have real, definitive issues for appeal. And that's why they made the decision that they made. This is a very serious issue that any American can lose their presumption of innocence, should be an affront to us all. And you all saw during the sentencing how Judge Lynn took it upon himself to not only sentence our client, which is his right as a judge, but to character assassinate him. Let's not forget that the least act of a man is not the measure of a man. And we had letters of support from the NAACP who talked about the disparate treatment that black males receive in the criminal justice system. It is time to have that conversation. And we are elated that the appellate court is able to decipher the legal issues here and apply the correct standard. And we look forward to this process playing out. Thank you.